Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. The responses from the state of Florida to the motions to suppress the cell phone data that the police obtained, as well as the Google searches, that was filed this week. And it posted to the county clerk's website a couple of days ago. So we're going to go through today on this one. I'm going to go through the cell phone response, the cell phone motion response from the state of Florida. So again, this is the filing up here. It was filed on 4/8/2025 at 4:31 and 58 seconds. Well, that means like 4:32, but they're very official. Again, this is the state of Florida versus Stephen Michael Stearns, and that's his case number. And of course, we know this is Division 12A. This is the state's response to defendant's motion to suppress evidence obtained from unlawful searches of cell phone. Now, I have not read this. I glanced through it briefly, but I wanted to read it first here and kind of get my initial responses here. I kind of have an idea what they're going to go through, basically from what I've heard from some of the experts around. And this is, as you can see on the top, if you can read that, this is 14 pages long. So I may push through parts of it. And I believe the second motion on the Google searches, that one's like 19 pages. So this is why I'm going to do it in two parts, because otherwise it'll be a very long video. Comes now the state of Florida by and through the undersigned assistant state attorney, and hereby states as follows. Procedural history. The defendant was arrested pursuant to an arrest warrant in the above style case on February 29th, 2024. On March 11th, 2024, the state filed an information charging the defendant with 8 counts of sexual battery on a child under 12, 5 counts of sexual battery with a child 12 to 18, familial custodial authority, 7 counts of lewd or lascivious molestation, and 40 counts of unlawful possession of materials depicting sexual performance by a child, 10 or more images. The state provided discovery to the defendant on March 20th, 2024, and discovery has been ongoing. On February 6, 2025, the defense filed defendant's motion to suppress evidence obtained from unlawful searches of cell phone. The motion alleged violations of the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution. Statement of facts. On February 26, 2024, that's redacted. I am assuming it's saying Madeline Soto. Orange County Sheriff's Office by her family. I'm assuming it says reported missing by her family. The family contacted law enforcement at approximately 4:30 p.m. There were 3 calls made to the Orange County Sheriff's Office prior to deputies arriving. At approximately 7:35 p.m., Deputy Frankie Joseph with the Orange County Sheriff's Office made contact with Jennifer Soto, the defendant, and members of Ms. Soto's family. All individuals were present in the lobby of the business building in which Miss Jennifer Soto's mother worked. Remember, this is Yolanda's business nearby the Hunters Creek Middle School. Deputy Joseph inquired as to the identifying information for, that's redacted, but I believe that's Madeline Soto, from Miss Soto and the family. The defendant stated he had dropped Madeline off at school that morning. The defendant described Maddie had been wearing a green hoodie, white Crocs, and either blue or black pants. Deputy Joseph was also told that Maddie had taken her cell phone to school that day and did not take her cell phone to that school that day and only had her school computer. At approximately 7:47 p.m., Jennifer Soto provides Maddie's phone to law enforcement to review. Sworn written statements are collected from the defendant and Jennifer Soto on February 26, 2024. The defendant's sworn written statements states as follows. Dropped off about a block or so from school sometime between 8:25 to 8:40 a.m. Turned around and headed back towards town. I watched in my rearview mirror as she made her way in the direction of school. She was busy searching through her backpack for something, but seemed to still be moving toward the school, so I carried on with my day. I stopped by a nearby vape shop, but it was closed, so I went home and left an hour or so later to check the shop again. It was open, so I bought my vape juice and returned home. Relaxed with Jen for a while, later went out in the afternoon for a few more errands and returned home around 2:30. Jennifer Soto's written statement states as follows. Today around 8 a.m. I saw Maddie getting ready for school. I am not sure what time they departed. Stephen Stearns took her to school and dropped her off close to school on Town Loop Boulevard between Town Center Boulevard and Hunters Park Lane around 8:30 to 8:45 a.m. She never made it to school. I went to school around 4 p.m. to pick her up and she never came out. I searched the area, went to my mother's office to look for Madeline and could not find her. That's interesting. They did not redact that one, so they missed a redaction. And I really hate this statement from her, and they are giving her a pass on this part. That is part of her derivative immunity. At approximately 9:05 p.m., accompanied by law enforcement, the defendant drove his vehicle to the area he claimed to have dropped Madeline off. The defendant stopped in the middle of the roadway and got out of his vehicle. The defendant claimed they were standing in the area in which he last saw Madeline Soto. Yeah, it looks like they had some issues with their redactments here. During this time, law enforcement provided the defense with Madeline Soto's cell phone. Deputy Joseph made contact with a church in the area and went through video surveillance. At approximately 12:30 a.m., Officer Tristan Clark arrived at the home of Jennifer Soto and was greeted by Ms. Soto and the defendant. Law enforcement was actively searching for Madeline Soto. Something successful. I don't know exactly what that would be. By all accounts, the defendant was the last person to have seen, Madeline 2024. That's a little hard to decipher there. Let me know what you guys think. On February 27th, 2024, at approximately 12 p.m., Detective Francis Hunt with the Orange County Sheriff's Office conducted an audio recorded interview of the defendant. Detective Hunt swore the defendant prior to asking him questions. The defendant reiterated the last time he saw Maddie, he dropped her off for school the day prior. During this interview, the defendant told Detective Hunt that he did not recall the exact time of the drop-off because he left his phone at home. It was also during this interview that the defendant stated that Maddie slept alone with him in the upstairs bedroom so Jen could get better sleep. The defendant also told Detective Hunt that redacted at the residence as well when they left for school. At approximately 7:16 p.m., an audio recorded interview with the defendant is conducted by Detectives Maria Tagler and Louis Acosta. The interview occurred at 4012 Santa Maria Drive, which is the Soto's residence. The defendant was not in handcuffs and was free to leave. I feel like that should be highlighted, but the two detectives who interviewed the defendant were in plain clothes. The defendant stated he and Madeline, they left the house between 7:30 and 7:45 a.m. The defendant again reiterated that he dropped her off at the school, near the school, prior to the day prior. The defendant detailed, and that's totally whited out, their route on the way to drop her off. The defendant indicated that he tried to go to the McDonald's near the middle school, near Hunters Creek Middle School. However, he did not stop at McDonald's. The defendant estimated he dropped Madeline off at approximately 8:20 a.m. To 8:40 a.m. At approximately 7:37 p.m., after the defendant relayed all this information, the following exchange occurred between Detective Tagler and the defendant. Detective Tagler, do you mind if I look at your maps real quick? Defendant, yeah, that's fine. Detective Tagler, thanks. The defendant unlocked his cell phone and handed it to Detective Tagler. There is some more clarification with Detective Acosta on the route the defendant took to reach the school and the location of where he had claimed to drop Madeline off. Detective Tagler has the following conversation with the defendant. Detective Tagler, do you mind if I just take a picture of your history? Defendant, yeah, that's fine. The defendant and Detective Acosta discussed what time the classes began at Hunters Creek Middle School. Their conversation continued. Detective Tagler, what kind of phone is this? Defendant, S23 Ultra, I think. Detective Tagler, I don't know how to work this thing. Defendant, I'm sorry, I barely know how to work it myself. Detective Tagler, I'm an iPhone person. Defendant, oh. Detective Tagler, is it okay if I go into your settings real quick? I just want to see if you're logged onto your Google. Defendant, I am not logged onto my Google with that actually. Detective Tagler, is it okay if I check? Defendant, yeah. There was some further discussion between Detective Acosta and the defendant regarding what type of digital devices, I guess redacted, I may have been Maddie, and where she kept them. Detective Tagler then had the following conversation with the defendant. Detective Tagler, hold on, I don't know how to use this phone. Sorry, I don't mean to interrupt. Brief conversation occurred about Madeline Soto's behavior. Detective Tagler, is this what you use to go to places? Defendant, yes, go places, search addresses, look at store hours, write reviews. It's a pretty new phone, though. Detective Tagler, when did you come back to help Jen? Is that her name? Defendant, what do you mean? Detective Tagler, because you live down south. When did you come back up north to help her? Defendant, I just got here this weekend. Detective Tagler, do you remember what day it was? Defendant, Sunday. Sunday was her birthday party, so yeah, it was the evening after her birthday party. Sunday. Detective Tagler, okay, do you remember what time you got here on Sunday? Defendant, 8 to 8:30ish maybe. Detective Tagler, okay. Defendant, just in time to make sure that she was doing all her nighttime routines, waiting for her mom to get home. Detective Tagler, you live in Northport, right? Defendant, yeah, I split my time between the two places. Detective Tagler, is that on Snug Street? Defendant, yeah. Detective Tagler, that makes sense. You have a lot of Snug Street on here. Defendant, yeah, I split my time between the two. Detective Acosta inquired as to whether the defendant and Jennifer Soto went anywhere to look for, Madeline, the day prior on February 26, 2024. The defendant denied knowing whether they went to look for Madeline because he had taken Ativan the night before because he had been so worried. Detective Acosta then went through the details of the directions for the route that the defendant claimed to have driven to take Madeline, to school. Then the defendant then went through this discussion again, but this time included time frames. Detective Acosta then indicated that the defendant's vehicle is not where he indicated he was according to the traffic cameras in the area. The defendant then indicated he went back home because he forgot his gate clicker. At 7:53 p.m., Detective Tagler handed the defendant his phone back. Immediately after handing the defendant his phone back, Detective Tagler stepped away from the defendant. Detective Acosta stays with the defendant and they continued speaking. At 7:57 p.m., Detective Tagler returned and has the following interaction with the defendant. Detective Tagler, can you unlock this one more time, please? Defendant, sure. Detective Tagler, I have a question. Defendant, yep. Detective Tagler, sorry, are you guys done? The other detective mentioned you did not have your phone yesterday. Defendant, correct. Detective Tagler, tell me about that. Defendant, I left my phone home in the morning, too. I was so busy riding her or, getting redacted out the door on time that I left my phone. She left her phone. We both left our phones. Yeah. Detective Tagler, did you have your phone when you went to the smoke shop? Defendant, not the first time after I dropped her off. I was still without it. Ugh, I got it, got my phone, it went back to the smoke shop. Detective Tagler, okay. Defendant, later when I was home. Detective Tagler, okay, I also noticed, I was checking your call history. I noticed that you don't have anything before this morning. Is that usual on your phone? Defendant, ugh, no, it's a new phone. Stupid. I went to do an update yesterday morning and I don't know what the fuck. Pardon me. I don't know what the heck I did, but somehow during the massive OS update I managed to factory reset my phone and lose all of my contacts, all my information. Detective Tagler, uh-huh. What time was that? Do you remember? Defendant, oh, sometime when I was hanging out with Jen. Jen might know. I looked at her and said, what did I just do? Detective Tagler, okay. Defendant, she might know better. I don't know what time it was. It was when I was here with Jen. Detective Tagler, okay, I don't think I have any other questions. At approximately 7:59 p.m., Detective Tagler advised the defendant that law enforcement was going to hold on to the defendant's phone. The defendant was told that he would receive it back when we are done. It was at this point that the defendant's phone was seized by law enforcement pursuant to this investigation. After this interview ended, the defendant re-entered Jennifer Soto's vehicle and remained in the parking lot of the apartment complex. On February 28, 2024, at approximately 12:16 a.m., Detective Tagler and Detective Acosta conducted a second audio recorded interview of the defendant. During the beginning portion of the interview, Detective Tagler advised that law enforcement had been going through redacted cell phone, I assume that's Madeline again, and noticed a lot of conversations between her and the defendant. Detective Tagler asked the defendant to advise as to what type of relationship he has with Madeline. Blank stated that she thought of me as a dad, thinks of me as a dad. Less than a minute into the conversation, Detective Tagler has the following exchange with the defendant. Detective Tagler, sorry, I don't mean to cut you off. Your phone, I told you I was gonna hold on to it, and that we would like to download your phone, right? Defendant, okay. Detective Tagler, is this something that I have your consent to do, or do I need to get a search warrant for your phone? Defendant, it should be fine. Detective Tagler, you're okay with us going through your phone? Defendant, yeah. Detective Tagler, okay, can I have the PIN to your phone? Defendant, ugh, 42586. Detective Tagler, 42586. Perfect. Thank you so much. Defendant, So there you go. There's an important part right there. Law and agreement. Consent. Warrantless searches are per se unreasonable pursuant to the 4th and 14th Amendments unless there is a recognized exemption to the warrant requirement. Farrer v. State and Katz v. United States, consent is a recognized exemption of the warrant requirement. The standard for measuring the scope of the consent given under the 4th Amendment is objective reasonableness. Florida v. Gemino. The state has the burden of showing by clear and convincing evidence that the defendant's consent to search was freely and voluntarily given. Norman v. State, citing Bailey v. State, and Sagonas v. State. Taylor v. State, and sorry, I'm not reading all that stuff on this one, guys. It's a lot of those Southern District, Southern D, and all that stuff. For a search to be deemed involuntary, the court must find that the defendant's will was overborne and his capacity for self-determination critically impaired. State v. Gimes, 34, and of course that's Southern D, versus Cox v. State, quoting Shudithloff v. Bustamante. All right. The question whether a consent to a search was in fact voluntary or was the product of duress or coercion, expressed or implied, is a question of fact to be determined from the totality of all the circumstances. While knowledge of the right to refuse consent is one factor to be taken into account, the government need not establish such knowledge as the sine qua non of the effective consent. As with police questioning, two competing concerns must be accommodated in determining the meaning of a voluntary consent: the legitimate need for such searches and the equally important requirement of assuring the absence of coercion. And you're seeing, I guess, that Sholoth versus Bustamante. In determining the voluntariness of the defendant's consent to search, the court must look to the following factors. 1. Whether the defendant was free to leave. 2. Whether there was any coercive police procedure. 3. The extent of the defendant's cooperation or his awareness of the right to refuse. 4. Whether the defendant could have refused to consent. 5. The defendant's education and intelligence. And 6. The defendant's belief that no incriminating evidence would be found. United States v. Ramirez-Chillo, citing United States v. Gonzalez. The defendant cites to Riley versus California for the foundation of their argument that the law enforcement overreached the consent given by the defendant, and Detective Tagler should have instead obtained a warrant. In Riley, the defendant was subject to an arrest for weapons violation after a traffic stop. The defendant's cell phone was in his pants pocket at the time of his arrest and was seized by law enforcement. Law enforcement searched the defendant's cell phone incident to arrest. There was no warrant for the search of the cell phone, nor was there consent from the defendant. The Riley court does discuss many considerations when dealing with digital data. However, the defendant's reliance upon the court's ruling is misplaced. Detective Tagler was not searching the defendant's cell phone incident to arrest. In fact, the defendant was not under arrest. Detective Tagler was viewing data on the cell phone pursuant to the defendant's consent for her to do so. The Riley court did not declare law enforcement must always get a warrant before searching a cell phone as claimed by the defendant. This is quoting page 23 of the defendant's motion. In fact, the Riley court recognized that even though the search incident to arrest exception does not apply to cell phones, other case-specific exemptions may still justify a warrantless search of a particular phone. One well-recognized exemption applies when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. Citing Kentucky v. King, quoting Mincy v. Arizona, the Riley court then gives hypothetical examples of exigent circumstances, exemptions, and fact-specific threats that may justify a warrantless search, such as a child abductor who may have information about the child's location on his cell phone. The scope of consent to search is generally limited to what a reasonable person would have understood to be the object of the search during the exchange between the person and the police. See Jacobs v. State. See Florida v. Gemino. Law enforcement officers are not required to inform citizens of the right to refuse to consent to a search. Smith v. State. Citing Shinlick. The scope of the consensual search is determined on a case-by-case basis. Allen v. State. See also Florida v. Gemino. The standard for determining the scope of the consensual search is objective reasonableness, i.e., what a typical reasonable person would understand the exchange of words under the circumstances to mean. Limited consent given by the defendant during the interview with Detective Tagler. The defendant does not challenge the voluntariness of the limited consent given by the defendant during the interview, and so the defendant claims that Detective Tagler overstepped the consent given by the defendant. The defendant's motion and argument depends on the defendant's misleading and incomplete recitation of the limited consent that he gave Detective Tagler during her first interview with him on February 27, 2024. However, the defendant fails to discuss the fact that the defendant unlocked his cell phone and handed it to Detective Tagler on 2 different occasions. The defendant also fails to acknowledge that he allowed and consented to Detective Tagler viewing map data, viewing and documenting the defendant's history, reviewing settings, and viewing the associated Google account and whether it was logged in. Detective Tagler did not exceed the consent given by the defendant during the first interview that occurred on February 27, 2024. At the end of the first interview of the defendant with Detectives Tagler and Acosta, the defendant's cell phone was lawfully seized by Detective Tagler. At the time the defendant's limited consent was given, the defendant was free to leave and did. The defendant was not in custody nor placed in handcuffs. There was no coercive police tactics or procedures utilized by Detective Tagler or Detective Acosta. The defendant provided Detective Tagler with his cell phone and unlocked it for her twice. The defendant was cooperative with law enforcement in his actions and his statements. The defendant was not specifically informed that he had the right to refuse to consent. However, it was implied in the questioning that occurred prior and during the limited search. The defendant could have refused to allow Detective Tagler to review the contents of his cell phone during the interview. The final factor for this court to consider in determining the voluntariness of the defendant's consent to search is whether the defendant believed any incriminating evidence would be found in the place to be searched. Quite frankly, the defendant believed there would be no incriminating evidence located in his phone because he had factory reset his phone twice on the day of the homicide, believing he destroyed all the incriminating evidence. Defendant's consent to a forensic download of his cell phone. Next, the defendant's motion turns to the consent given by the defendant for the full forensic download of his cell phone. The defendant gave consent to law enforcement to download and go through his cell phone during the second interview by Detectives Tagler and Acosta on February 28, 2024. The consent was obtained from the defendant at approximately 12:17 a.m. outside of the residence of Jennifer and, I'm assuming, Stephen Stern's defendant frequently visited. Prior to consent for the full forensic download, there is no evidence of prior police misconduct or coercive tactics. The defendant made no attempt to limit or withdraw his consent after he gave it to law enforcement. A reasonable person would understand that giving law enforcement consent to download the cell phone and go through the phone would allow law enforcement access to the contents of the cell phone in its entirety. During the interview in which the defendant consented to the download of his cell phone, he was free to leave. Defendant was at the home shared by Jennifer and himself, which he frequently visited, and was not handcuffed. The interview took place outside of the residence. The defendant argues that he was coerced into consenting to the download because law enforcement refused to return his phone, and there were threats to obtain a warrant. Yeah, that didn't happen. However, the defendant's cell phone was properly seized by law enforcement. Also, advising the defendant that law enforcement would like to download his phone and stating, "Is it something we have your consent to do, or do I need to get a search warrant for your phone?" is in effect requesting consent from the defendant as well as advising him of his right to refuse consent. Detective Tagler then subsequently followed up with the question, "You're okay with us going through your phone?" At which point defendant responded, "Yes." There were no coercive tactics by detectives in obtaining the defendant's consent. The defendant, based upon the interactions, reasonably understood he had a right to refuse consent. The true foundation of his willingness to have law enforcement search his phone is that the defendant believed that he had erased all incriminating evidence from his phone after he performed 2 factory resets on the cell phone 2 days prior. Law enforcement received consent from the defendant to download and review the contents of his cell phone. Law enforcement did not exceed the scope of the consent given by the defendant. Conclusion. Law enforcement legally searched the defendant's cell phone of February 27th, 2024 and February 28th, 2024, pursuant to the defendant's voluntary consent. Therefore, the defendant's motion seeking to suppress evidence recovered from the searches of the cell phone should be denied. And of course, it is certified and it's signed by the Assistant State Attorney, Daniel Marie Pinnell. I think they covered their bases extremely well. I think the Assistant DA gave a really good argument. Of course, they'll have more to say on April 23rd when they argue this motion in court, but I foresee that this will be denied. He was clear. We've heard him say it. We've heard the interviews from the audio interviews, and of course we've seen the interviews at the station, the police station, with Stephen Stearns and Jennifer Soto. He gave them his phone. He unlocked it like they said, and he basically said, "Sure, go for it." And the only thing he was concerned about, he ever expressed concern, was that he didn't have a way to reach his father. And she said, "Well, you can use Jen's phone." But he never said no. Like they're stating in their response, he thought by factory resetting his phone that he was going to erase all that nasty CSAM stuff that he had. He was very, very, very wrong. And, you know, once it's there, it's there. I mean, it's in his Google Drives. And, you know, he's screwed. He basically is screwed. He did horrific things to poor Maddie. And they found every single bit of it. And I'm sure there's more that we haven't even heard about, which is very, very sad. But let me know what you guys think of hearing this particular response from the state. I was kind of hoping Mr. J would write it, but I like the way she writes too. It's very easy to understand for the most part. I will see. I don't know if she wrote the second response. I'm assuming she did. But again, let me know your thoughts. I will go over the second response on the next video. And of course, we've got so much more coming with the pre-trial and the hearing on these motions coming up in a couple weeks. With that said, I hope you guys have a great rest of the day. And most of all, stay safe.